All right, joining me once again here on the Matthew Filipowicz Show is my good friend Sarah Jaffe. Sarah is an independent journalist whose work has been seen in Truth Out, Jacobin, The Nation, Alternet, and many more. She is the co-host of Dissent Magazine's Belabored podcast, all of which and more you can find at adifferentclass.com. You can also find her on Twitter at Sarah L. Jaffe. Sarah, thank you so much for being on the show again.
Thank you for having me, Matt.
All right, so Sarah, with last week's Supreme Court decisions, when they came down, a great deal of focus was on the insane Hobby Lobby ruling and how that affected women. But you actually recently wrote a piece on how the anti-union decision in the Harris case also drastically affects primarily women. Tell us about it.
So, right, home healthcare workers are a workforce that is 90% female. Most of those are immigrants, women of color, low-income women across the country are doing this work. And so when you look at this, and also it's a highly gendered kind of work. So, you're caring for sick relatives, children, the elderly, neighbors. It's that kind of work that not only is overwhelmingly done by women, but that we overwhelmingly expect to be done by women.
Yeah, no, absolutely. And again, most of the people in this case are women. Do you think, like, it's so, again, I'm still just sort of shaking my head even more, like, at how blatantly sexist this court is and how insane they are. It's almost like cartoonish villains almost, it's like still the and I want to definitely kind of stick on Harris, but the Hobby Lobby ruling is so crazy and so large and so vast, and it's just sort of like their hatred of women and their love of corporate, but like the implications of what comes from out of Hobby Lobby are crazy. But what do you think are the implications that come out of Harris, like specifically?
I want to stop and say, like, I want to make sure that we talk about these things. It's not crazy, and it's not, it's about power, and it's very deliberate. And so when we look at who gets screwed in cases like this one, right, it's very specific. Like the Harris v. Quinn was an attempt to try to take union bargaining rights away from, or to take, dues checkoff is a complicated thing, but essentially it was an attempt to attack all public sector unions. And what they got out of it was a more narrow thing than they wanted, and it only affects sort of the poorest and the least able to organize and to have actual power themselves. And so when you look at that, it's sort of the next step, right? They do this, and we see how this goes, and they lay down some precedent in the court for this. And then the next time around, the next lawsuit is teachers who don't want to have to pay union representation fees, and then they try to take out teachers' unions. Teachers who are also majority female, right? The Hobby Lobby case, right, again, it seems ridiculous in that it's, again, when we say narrow, we have to be, again, careful on this stuff, but, it's just birth control that employers can refuse to provide. And though the Hobby Lobby, the bosses there, were only opposed to certain kinds of birth control, a statement that the court put out a few days later elaborated that you can refuse to provide any birth control at all.
Right.
But just birth control. A Jehovah's Witness employer cannot refuse to provide health insurance that covers blood transfusions, even though they religiously don't believe in blood transfusions. Presumably a Christian Science workforce could not refuse to, it's very specific. And
but also why it's only specific because they say it's specific. I mean, there's no logical reason for it not to not extend it out, right?
The reason for it to be specific is that we're just kicking the women. We're just taking these rights away from women workers, right?
Right.
We're not going to take them away from all workers, and it's a little bit of a wedge in there to get the next time. So, I said this in the piece I wrote, right? The attacks on all workers usually come first for the least powerful, the most vulnerable workers. And that often don't get thought of as workers at all, which is how the Harris case actually hinged, right? The women who were arguing against the union in this case, we're saying, I don't want my home to be a union workplace. But, for many of these people, they do want the home to be a union workplace because they necessarily their family members. They are thinking about it. They are having rules on the work that they do set by the state. And in that way, right, the home is and can be a union workplace.